The original complaint was filed on, when was this date? Did I block it out? 410 or whatever, right? And he's suing Koil and Mitchell Clout, which is Koil Content Creation is Mitchell Clout's company. That's Koil's real name. All right, guys. And you see this from time to time. He's suing them for declaratory relief and breach of contract. Now, if you've been following my content, I've been clipping everything and uploading it for videos for you guys so you guys can see it. He filed his lawsuit. Koil responded he asked for some more time. He asked that his new response date be June 15th, 2023, which today is June 16th. You like, Henry, Henry, do you got his shit already? No way you have his stuff already. The ink ain't even dry yet. It's not dry, Henry. How'd you get? Look, I got it. we can skip all the bull BS right now. Yes, I have Koil's response. It was filed on the 14th, and I have it. But before we get to that, right? Before we get to that, I do want to play this video, right? Because this was rumored why DW was not involved. We showed you some past clips where Koil alleges that DW didn't do the work. And when he fired him or took him off, he stopped using pay priority for the GTArp server. And, guys, let me make you fully aware. I am not the most knowledgeable, as the reporter I was talking to, I don't know if you're still in the chat, of everything. So I'm mostly speaking on the clips I see and the court documents, because the judge is just going to go off the court documents. They're not going to be like, well, let me look at this video that he said.
I like TV's one of them. So the pay prior was not my idea, right? It was a DW thing, and that's how I was paying him. That was one of the ideas that he brought up.
Okay.
And he was getting paid a fucking shitload and still didn't finish half anything, really. We had the other devs that ended up doing it. But he kept the money, dude. Good guy. Great guy.
All right. Listen to this, guys, because this is actually going to come back up in the lawsuit. I'm only playing this so you know that, hey, DW, he set up pay priority. He paid him to develop it. He paid him up front. He didn't finish, and he kept the money.
Just fuck, and I just juiced up some of the other devs anyway. Yeah, DW ain't at Nopixel no more. I don't know what happened, dude. It was strange. It was really, really weird. A lot of strange shit happened. And the craziest shit of all, the thing that I think made him snap, which is like, it's the strangest, is the controller changes, all right? I think that is actually legitimately what made him snap. Does that mean Buddy is gone too? No, it does not.
All right, so if you don't know, DW, he worked for One Video, right? One Video is suing Koil, which looks to be on the behalf of DW, okay? Because they're like, hey, our man didn't get paid. We got to sue because DW is not a citizen. So you can consider DW maybe a subcontractor, okay? But his deal is with Nopixel.
No, I'm serious. Pretty much he went into dev chat and said, hey, this is fucking retarded. And I was like, I said something like, listen, just because your boy's mad, it is what it is. You don't have to get angry about it and say it's retarded and shit. And then he just didn't talk for like a week or two. And I was like, okay, maybe just like chilling and sorting things out. And then I was like, yo, what's up, man? Are you what you doing next year and shit? And yeah, he pretty much gave an ultimatum of certain things that are like they were pretty absurd, dude. But the worst part is, like, I had already paid him for work, and he was making ultimatums after that to, essentially hold money that he was paid for ransom. So
I'm breaking it down. I'm pausing so you guys see it. Hey, I paid him for work. He got the money. The next thing you know, he started giving me ultimatums before the work is done. But he still has the money.
Really awkward situation when somebody is paid to do something and they don't, like, I don't think he really saw it as a job in a way. And that was the big issue with it. It's like, there's a lot of money too, like a lot of money, chat. You know, I was trying to help him out with his because he was fucking worried about all his visa and all that sort of shit. Why would you? Yeah, I really wouldn't be able to sue him, man, and I wouldn't do it anyway, to be honest.
Notice he said I wouldn't be able to sue him. I could sue him, but I wouldn't do it anyway. If I heard him correctly.
I don't know if he was just going through some shit IRL or something, but like, it was just strange. It was really fucking strange. Like out of all the hills you could die on, though, it being fucking controller changes was the weirdest.
Well, it sounds like they had creative differences, guys.
I don't think he really thought about like it from outside that much, and that's why I think he why I say like I don't think he saw it as like work. He saw it as like I don't know. It's hard to describe it in all honesty, but when you come into modding, you don't consider yourself working, right? Because you do it for the enjoyment. But when someone starts saying, "Hey, listen, I'll pay you. You have to do X, Y, Z," and you agree on it, at that point, it's a job, in my opinion. I mean, it's a contract at that point. Really.
I hate that he says contract because when you see the legal stuff, he's going to argue that it's not a contract.
I mean, at the end of the day, you know, shit on the internet, it's easy to fucking like, you know, I guess avoid consequence and not really understand the emotion from the other side, I guess. So I'm not all that fussed about it, but like I still think it's fucking absurd either way. He got bought out by SVRP. I don't know, man, dude. I just think I don't know, dude. It felt like a Dundee type deal. I actually did quite a bit of damage there. Like you come into something and you feel like you own a part of it just because you either, you know, worked or you know, just tried to pay off every streamer on the server or some shit. That's what I think a lot of the issue was. But
that's what I want you guys to hear. You work on something, you feel like you own it, you're a part of it. Now let's get to the court docs. What did Koil respond with? It's a motion to dismiss the case, but he also gives a reason why. And I see we got the new world order. They slowing me down on my streams. Don't worry. Here is Koil's response. It is dated on the 14th, and we don't have to read everything because some of it is just a little bit of legal talk. And sometimes when it's all this legal talk and stuff, I don't whatchamacallit. Now, as far as why did DW not like controllers, I have no idea, man. That's a Koil question. That is actually a DW question. I can't answer that. Okay. And I don't play GTArp, so you know, I'm not the most knowledgeable. All right, so what does he say? Koil responds to One Entertainment, who was suing on behalf of DW. Now, they have a trial, the hearing date, not a trial, a hearing on the motion to dismiss July 17th. All right. This is what Koil is saying. Okay. Please take notice that July 17th at 1:30 or as soon as thereafter, the matter may be heard before a judge. Okay, defendants Koil and Mitchell Clout will move the court for dismissal of One Video Entertainment's complaint. Okay, I'm not. Look, when it comes to too much legal stuff, I am not gonna go into like the statute rule 12B-6 of the federal rules of civil procedure. We're not doing that. I'm giving you the too long didn't read. Okay. So plaintiff has not stated a claim for declaratory relief in that there is no actual controversy to be adjudicated. Okay. So there's no issue. That's where you see what's the issue. It's not clear since DW was paid for the work. That's where it's like, hey guys, there's really no issue. He was paid for the work. What is he suing me for? We stopped using paid priority when I fired him. There's no money owed. Okay. Second, this is not a claim that asks for a remedy expressively granted by Copyright Act or which requires interpretation of the Copyright Act or which federal principles should control the claim. And I brought this up when I initially start covering the lawsuit that there's a copyright application, but there is no copyright for paid priority. Okay. Now, this is where it kind of gets a little legal ease. If the claim for declaratory relief is dismissed, as in you're not asking for nothing, then the claim for breach of contract must be dismissed because there is no longer any federal court jurisdiction over the claim. So if you get, look, I made it simple for you guys. If A equals B and B equals C, then A equals C. Oh, algebra, but way back in the day. So if you dismiss the declaratory claim, then there's no lawsuit. See how it works? Okay. Now, plaintiff does not allege an agreement. Now, this is trying to get him get Koil off the hook personally. Just get Mitchell Clout off the hook because you have two things, right? Remember, if I'm Henry LLC and then you want to sue Henry LLC and HenryResilient, those are two different entities. You have to pick one. So Koil is saying in his motion to dismiss, which he's going to go in further detail, that the plaintiff has not stated any causes of action against defendant Mitchell Clout, and that plaintiff specifically states in the original complaint that any alleged contract was between plaintiff and Nopixel, i.e. Koil. Okay. i.e. Koil. Okay. According to even look, guys, these are straight court documents. Don't hold me too crazy. Accordingly, even if the court finds that the plaintiff has stated a cause of action against Koil, Clout, you have to remember, Clout, the person, should be dismissed from the complaint. Because look, I'm breaking it down. The agreement was with Nopixel, not Mitchell Clout explicitly. Okay. You can't sue two people for the same thing. It just doesn't work like that per se. Okay. We're going to keep going. Now, this motion is based off all this stuff that I'm not reading right here. This is just legal talk, guys. I would never just skip anything that would favor one side or the other. Okay. If I've read this document, I'm pretty familiar. I've even put notes on it. Now, this motion was made following the conference of counsel pursuant to 7-3, which took place on May 24th, 2023. So basically saying, hey, we came to this plan on May 24th that we wanted this shit dismissed. That's all this is, guys. They signed it June 14th. Now they have to submit a little bit more detailed statement because you can't just be like, hey, I want this shit dismissed. Here's 4 sentences. Dismiss the case. It don't work like that. Okay. It does not work like that. So we're keeping it going. All right. Truing. Look, guys, only thing I'm going to do here.
That's a truthful statement.
Is make truthful statements. All right. Based on the court docs. Okay. All right. Plaintiff, which is DW, has filed what is fairly a basic breach of contract lawsuit against the defendants. Now, this is a little, you kind of downplaying it. I believe he's looking for 150,000. And I believe the threshold for state court and federal court, it may be 50 or 75,000. It's one of those. And typically when you want to get your lawsuit heard in federal court, like Nicki Minaj did, like Cardi B did, is you sue for something above the threshold. You want to get it out the state and get it at a federal level. That's typically how it works. All right. And look, this is not legal advice. This is just legal information. So, however, instead of following the action in the Los Angeles Superior Court where it belongs, plaintiff filed the action in federal court. So they're just saying wrong venue. Okay. Wrong venue. Right there. That's anything in blue on the side is my stuff. Okay. There is no good reason why federal court should have jurisdiction over this case. All right. State courts are fully competent to adjudicate state law breach of contract claims, even where the underlying contract involves ownership, assignment, or a license of a copyright. I hate that they use copyright and you're going to see it. Okay. So now they're saying, hey, wrong venue. And they keep going on. Now they're saying, hey, moreover, with regard to the declaratory judgment claim, there is no actual controversy that the plaintiff is seeking to resolve. Okay. The claim for declaratory relief is merely seeking an advisory opinion on whether it is entitled to assert joint ownership in the copyright derived from Mr. Tracey's creative contributions to the Nopixel server. Now, to be fair, what he did is not a copyright, and they're gonna call that out later. Okay, plaintiff does not claim it is using copyrights, or the defendant has treated or threatened to sue plaintiff for copyright infringement for this use, because no one uses paid priority anymore, right? Because the agreement was that if DW gets a cut 50% of all paid priority only revenue, emphasis on paid priority. When he got fired or let go or whatever, they stop using paid priority. Those are the court docs. Okay. 50% aware. All right, cool. Finally, the complaint does not state a claim against Mitchell Clout. So look, guys, Mitchell Clout, which is Koil, is trying to get out of this lawsuit because you do not want to get personally sued at all. You sue the company, you got an LLC, protect your personal assets. But what tends to happen is when people file these lawsuits, they want to get everyone involved. So they're going to sue you, they're going to sue your company, they're going to sue your friends, they're going to sue whoever they can to wrap up in this lawsuit net. That's just typically how it works. Okay? Look, the complaint does not allege that Clout has any ownership interest in the copyrights to the server, which they assert he does not, nor does the complaint allege that Clout is the party to have alleged contract between TOVE and Nopixel. Mitchell Clout did not make the contract. The contract was between Nopixel. For these reasons, the complaint should be dismissed and the plaintiff should be instructed to file his claims in superior court. Guys, they don't want this shit in superior court whatsoever, probably because it's expensive as hell. All right. So let's keep going. Now, these the factual background facts, these are all from whatchamacallit. Plaintiff TOVE is a California limited LLC located in Torrance, California. Koil, aka Nopixel, is an Australian proprietary limited company located in Victoria, Australia. Okay. They basically regurgitate that, hey, Clout lives in Australia. You know, at some unstated point in time, TOVE hired a software developer, DW, as its lead developer. Okay. That's what happened. TOVE was permitted to contract with third-party services, Tracey, in exchange for Tracey's agreement that TOVE would be entitled to receive all compensation, such as third-party services. Basically, DW works for TOVE, okay? No one pays DW, they pay TOVE, TOVE pays DW. That's how it works. It's just a subcontracting thing. All right, we're not going to read all of this because this is all things that could be found in the previous videos, or you could pause the video and read what's on here. But that's all old stuff. Okay, let's get to the good stuff. This is where it gets good. Anytime you see red rhymes with dead. So plaintiff states and alleges that the agreement was entered to in early 2020, but in paragraph 26, plaintiff states the agreement was in mid 2021. All right. So plaintiff does not state whether this alleged agreement was oral or written, which I pointed out last time. I'm in corporate America. No written agreement. It didn't happen, even though we got Koil saying it's a verbal contract. Okay. So nor does the plaintiff, which is DW, allege for what period of time Nopixel agreed to pay TOVE 50% of its revenue. Guys, for a contract, you need to have a length of time. There is no contract that lasts forever. Okay? That shit does not exist. And if it does, it will likely get thrown out unless you are a record label. And then they're going to be like, you signed for life. They're going to like, for how long? For life. We don't know how long it was. We don't know if it was oral or written. All these terms are whatchamacallit, are just, you can say it's up in the air, but it's really not because we got the video. Okay. Nowhere in the complaint does plaintiff allege that TOVE entered into an agreement with Clout. So now they're getting very specific. So now they're saying, well, we entered into a contract with DW. but TOVE is suing us. So now you got some semantics. You got some semantics going on. Got some semantics. So technically, it was not a contract in the court of law. This is me right here. It does not look like a contract in the court of law. My interpretation, I could be wrong. The judge is going to decide. Let's keep it going. We only got a couple more pages. Now, defendants have breached the agreement by failing and refusing to pay 50% of the revenue generated from Nopixel. All right, that's what they're alleging, right? An actual controversy has arisen between TOVE and the defendants regarding the parties' respective rights in and to any and all copyrights derived from Mr. Tracey's creative contributions to the Nopixel server and monies generated from the exploitation thereof. This is, I hate that there's nothing written down, guys. I hate it. I hate it. I hate it. Did they breach the contract? They're saying Koil breached the contract because he didn't pay him the money from Nopixel. Think about this, right? Think about this. You are Koil and you talk to DW. You give DW the money and he then in turn does not turn it over to TOVE. Okay? Because he's supposed to, because he's TOVE's employee. And they got some type of slave labor contract where all his money goes to them. But TOVE is suing Nopixel for not paying them. This is my interpretation of it. My interpretation. Okay. And they're using Mr. Tracey as like the pawn, the medium, the conductor. So Koil says the court should dismiss the first cause of action for a declaratory judgment because there is no actual controversy. So they're basically not agreeing that a controversy exists. They're saying, hey, we paid. What are you talking about? We paid DW. TOVE like, no, you didn't. So now you got that. Okay. They go through the Declaratory Judgment Act, which we're not about to read that shit. We want the meat and potatoes. We want the meat and potatoes. Plaintiff merely makes a conclusionary statement that an actual controversy has arisen between the parties, but gives no details to what the controversy is. Even though they're kind of saying, hey, you did not pay us. Like, they're like, well, we paid DW. Yeah, I don't know. Did you? Plaintiff does not allege that it is using any code developed by Tracey, so they are aware that they stopped using paid priority code, nor does it allege that Koil and Nopixel has made any threat to DW to sue for copyright. Okay? They stopped using the code, which is smart on Koil's end because he knew the lawsuit was coming or he suspected it was coming. So if you team Koil, you paying someone for some code, you fire them, you stop using the code. And does he have receipts? Probably not. This shit is all on a verbal thing. So maybe he has wire transfers. Okay. Wire transfers at best. But as far as receipts, I don't think so. You know what I'm saying? Like, it's just phone calls. So maybe he recorded the phone calls, but it gets so murky, guys. So murky. But as pled, the complaint merely asks the court to provide an advisory opinion as to the parties' respective rights to the copyrights derived from DW's work on the server, which I told you it's not a copyright. Even if you were me and you pulled the copyright application that was filed is pretty bare. It's bare as shit. There's no copyright number or anything. It's essentially PayPal. And I've said it like plenty of times. I'm like, so he set up PayPal for pay priority. Anyway, let's keep going. Okay. The Supreme Court has held the following to a standard to bring action for declaratory judgment. We don't have to read that at all. Because I actually have something that kind of explains it for you. And I'll share it right here in my notes. I'll make it bigger so you guys can see it. That kind of like explains declaratory relief a little bit, because they're saying, hey, you didn't explain anything. Plaintiffs seeking declaratory relief must show that there's an actual controversy, even though the declaratory relief will not order enforceable action against the defendant. Hey, did something bad happen? Did you show it? Or they're just asking for an opinion. Do they own the copyright to PayPal for paid priority? Okay. That's all. Look, I'm just going through this as quickly as I can to kind of dumb it down for you guys and myself so everyone can understand it, even if you're not even following Nopixel. Like some of my day ones, they don't know nothing about this. So an actual controversy means that there's a connection between the challenge conduct and injury and redressability that a court could order. Okay. This is my Nopixel arc chat. Look, I got to stop reading chat. Let's get back to it, guys, because we're almost through it. All right. So there's that. They're saying, hey, there is no controversy. Your man got paid. They're saying we didn't get paid. We need an opinion if we own the copyright to pay for pay priority. And they like,
nope.
There is no copyright. Okay. We don't even use your goddamn code anymore. And look, I'm not supporting DW or Koil, but I'm just interpreting the court docs like as they are written. Now, keep in mind, both sides are going to say they're going to oppose each other no matter what. Okay. So if you stop using the code and pay it up front, what is the case? This is me reading this shit. I make these notes as I'm reading. I'm like, he stopped using the code. Okay. What's the problem? What's the problem? What's the problem? Now look, I'll go slow because I'll clip this if you want to go back and read this, but this is just a court case that kind of just support this. And they say, hey, back in this court case, they didn't prove anything. It was a controversy and they got dismissed. Okay. So we should get dismissed too. This is how it works. And shout out to my mods or whatever on Twitch. All right. Part 4. The fact that the case has some ties to copyright law is not sufficient grounds to justify a court jurisdiction. The some ties is the code. Now, you really I don't think you can copyright code per se. I'm not a copyright lawyer, but if you're trying to copyright PayPal's formula, anyway, plaintiff will probably argue so now they're anticipating what they're going to argue because DW gets to respond to this, guys. And I'll get the response, okay? Plaintiff will probably argue that the federal court should retain jurisdiction because this case is tangibly related to a copyright dispute. But just having a copyright element in the case is not sufficient reason to retain federal jurisdiction, okay? And that's what I said. There is no copyright on file, but I see the element since DW set up the payment using his code. You see how it works? There's no copyright on file, but it is his code, but they're not using it and they paid him up. What is the issue right here? Okay. But, hey, they want it to be heard in state courts. That's Koil's prerogative. It could be some legal strategy. Maybe it's cheaper. State courts are fully competent to adjudicate state law breach of contract claims, even where underlying contract involves ownership, assignment, or license of copyright. That's all. Look, hey, get this shit out of federal court. And look, they clap back. The word copyright is not so compelling to invoke federal jurisdiction upon its mere mention. Yeah, I kind of agree, but it's the money that they're seeking, which I believe is $150,000. Hey, look, everyone wants their bag, guys.
Gotta get my bag and run.
Everyone wants their bag. Okay. All right, let's keep going. Of course, if the court agrees to dismiss the first cause of action, then the entire case should be dismissed. Plaintiff is only bringing the breach of contract claim under the doctrine of supplemental jurisdiction. So, hey, remember, if they believe that there is no declaratory relief being requested, then the case is gone. But that's for a judge to decide and DW's team to respond to, guys. Okay. Now, the complaint fails to state a cause of action against defendant Mitchell Clout. And guys,
That's a truthful statement.
you should not be able to. You should not be able to sue the owner of the company and the company. It's either or. And usually it's the company, not the person. All right. Even if the court were to decide the complaint stated a valid cause of action for declaratory relief, defendant clout should be dismissed because in no event does the complaint state sufficient facts to state a claim against him personally, which I agree with 100%. You sue the company you did business with, not the owner personally. All right, there we go. Let's keep going because we're almost done. The complainant identifies clout as Nopixel's founder and owner. Other than this fact, the complaint does not state any facts that will give rise to a claim against clout personally for declaratory relief or breach of contract. With regard to declaratory relief action, the complaint specifically alleges Nopixel operates the video game server. Now look at this. I love how they put the most successful role player server in this kind. It's like, Henry gonna read this shit and we need him to plug Nopixel, okay? But anyway, it's all good. It's all legal stuff. And that Tracey was hired to work on and did work on Nopixel servers. Now look, I told you guys, this is a legal tactic. I've seen it in every case. I've seen it with CryptoZoo. You see it with OTK where they sue Ms. Kiff, the person. They sue his company. They sue the other company. They're suing everybody. Same thing with CryptoZoo. They sued Logan Paul. They sued all his people individually, and they sued CryptoZoo. Okay? This is, you just want everyone wrapped in to get a response. All right. The complaint does not allege that the servers are in any way personally owned by Clout, right? Who owns the servers, guys? Who owns the servers? The servers are owned by Nopixel, not Clout. As such, Clout does not personally own any copyrights at issue in this case. I told you there's nothing copyrighted in it. You can't, I don't know if you can copyright code. I don't think you can. Nopixel owns the server, not the person. Any business you buy or own and operate, you don't put no asset in your personal name because then you open yourself up to personal lawsuits. You put it in your company's name. All right. Similarly, with regard to the second cause of action for a breach of contract, the complainant specifically states that the alleged contract was with Nopixel, not Clout. And they kind of, these right here are quotes. Right here, quotes. Tracey rendered services to Nopixel. Tracey designed and created the entire payment processing system utilized by Nopixel server. During Mr. Tracey's engagement with Nopixel, commencing in or about mid-2021, TOVE and Nopixel entered. It's all TOVE and Nopixel, okay? It's not Clout, Mitchell Clout. So I'm in agreement that Koil the person should be removed from this lawsuit, okay? The complaint is completely devoid of any allegations that Tracey or One Video Entertainment ever entered into an agreement with Clout as an individual. So accordingly, the court should dismiss Clout from the complaint with prejudice. Prejudice means they can never sue Clout again under these guidelines, okay? Never sue him again. Conclusion, we're at the end. Because the plaintiff failed to plead facts showing an actual controversy, which is the payment, at the first cause of action should be dismissed, as well as the second cause of action for a lack of supplemental jurisdiction. Furthermore, Mitchell Clout should be dismissed from the complaint with prejudice. What do you think, guys? He is streaming? Oh, sweet. Shout out to him. BW or Clout or Koil? Is that why everyone popped on over here? I saw my Twitch numbers get juiced up. I'm like, somebody is sending people over here or whatever. So he's asking for three things. Did you guys catch the three things that he's asking for? Or y'all like, y'all got bogged down in all the words? I'll recap it right here on my screen. So 3 requests. All right. Let me show you. Let me break it down for you. 3 requests, 3 Koil requests. All right, let's do this shit in order. What is he requesting? 1, he wants to be personally removed from the case. All right, which I agree. I agree with. Him as the person should be personally removed. There's nothing that ties him. 2, he wants the case dismissed. Okay, case dismissed on the grounds of there's no look, how can I spell controversy? Did I spell it right? No. They like,
Nope.
no, controversy. All right. And 3. What else does he want? If heard, he wants it in a state judge. Move to state court. Okay. Those are the 3 things that he's asking for. Even that's it. Hey, I need to be removed. I want the entire case dismissed. And if we hear it, move it to state court. Hopefully, I explain this to you to the best of my knowledge, but these videos will get up.